Hello students, in this video I am going to discuss with you people a new topic, that is condition and warranty of your unit 2. The parties are at liberty to enter into a contract with any terms they please. As a rule, before a contract of sale is concluded, certain statements are made by the parties to each other. The statement may amount to a stipulation forming part of the contract or mere expression of opinion which is not a part of the contract. If it is a statement by the seller on the reliance of which the buyer makes the contract, it will amount to a stipulation. If it is a mere commendation by the seller of his goods, it does not amount to a stipulation and does not give the right of action. Subject matter of contract of sale is essentially goods. According to yes, if the stipulation forms the very basis of the contract or is essential to the main purpose of the contract, it is a condition. The breach of the condition gives the aggrieved party a right to treat the contract as repudiated. Thus, if the seller fails to fulfill a condition, the buyer may treat the contract as repudiated, refuse the goods, and if he has already paid for them, recover the price. He can also claim damages for the breach of contract. Warranties. Warranties, if the stipulation is collateral to the main purpose of the contract, that is a subsidiary promise, it is a warranty. The effect of a breach of warranty is that the aggrieved party cannot repudiate the contract but can only claim damages. Thus, if the seller does not fulfill a warranty, the buyer must accept the goods and claim damages for the breach of warranty. Now, question is when condition sinks to the level of warranty. In some cases, a condition sinks or descends to the level of a warranty. The first two cases depend upon the will of the buyer, but the third is a compulsory act as a stopper against him. First is a condition will become a warranty where the buyer waives the condition, or a condition will sink to the level of a warranty where the buyer treats the breach of a condition as a breach of warranty, or where the contract is indivisible and the buyer has accepted the goods or part thereof. The breach of condition can only be treated as a breach of warranty. The buyer can only claim damages and cannot reject the goods or treat the contract as repudiated. What are the implied conditions and warranty? Even where no definite representations have been made, law implies certain representations as having been made, which may be warranties or condition. An express warranty or condition does not negate an implied warranty or condition unless inconsistent therewith. There are two implied warranties. First is implied warranty of quiet possession if the circumstances of the contract are such as there is an implied warranty that the buyer shall have and enjoy quiet possession of the goods first. Second, implied warranty against encumbrances. There is a further warranty that goods are not subject to any right in favor of a third party or the buyer's possession shall not be disturbed by reason of the existence of encumbrances. Now, what are implied conditions? Implied conditions can be divided into different categories. First is condition as to title. There is an implied condition that the seller in actual sale has the right to sell the goods, and in an agreement to sell, he will have a right to sell the goods at the time when the property is to pass. Implied condition under a sale by description. Goods must correspond with the description. Where A buys goods which he has not seen, it must be sale by description. Example, where he buys a new Fiat car from B and car is not new, he can reject the car. Second is good must also be of merchantable quality. Merchantable quality means that the goods must be of such as would be acceptable to a reasonable person having regard to prevailing conditions. Next is conditions as to wholesomeness. The provisions, that is, suppose that is eatables supplied, must not only answer the description, but they must also merchantable and wholesome sound. F brought milk from A and the milk contained typhoid germs. Where wives became infected and died, A was liable for damages. Condition as to quality or fitness for a particular purpose. Ordinarily, in a contract of sale, there is no implied warranty or condition as to the quality or fitness for any particular purpose of goods supplied. Implied condition under a sale by sample. In a sale by sample, there is an implied condition that the bulk shall correspond with the sample in quality. There is another implied condition that the buyer shall have a reasonable opportunity of comparing the bulk with the sample. Further, an implied condition of merchantability as regards latent or hidden defects in the goods which would not be apparent on reasonable examination of the sample. In a sale by sample as well as by description, goods must supplied must correspond both with the sample as well as with the transaction. So thank you so much class. This video was all about conditions and warranties wherein I explained you what is condition, what is warranty and what are the different express and implied conditions and warranties. Thank you so much.